In today's video, I'm going to talk about what to do if you have found yourself in the very difficult situation of being served with a debt collection lawsuit. Now, if you've ever had this experience, it can be really unsettling. It feels very invasive because they actually come to your house, whether it be a process server, constable, even some states use sheriff's deputies will come by and they'll serve you with a copy of the complaint and the summons. This is the actual debt collection lawsuit. They always come at weird hours because they want to make sure to get you home. A big favorite seems to be early Sunday mornings or maybe late in the evening. You hear that knock on the door. You go there and there's someone serving you with legal documents that says you owe a bunch of money. Now, what I want to tell you here is that this first 48 hours after you get served, there's a lot of things you can do. They're going to put you in a better position to be successful overall with dealing with this issue, putting it in the rearview mirror and be able to move on. But before we even get into those steps, one piece of advice I would give you is don't avoid service. A lot of people think if I can just avoid the process server, avoid the constable from coming over and serving me with a complaint and summons, that I will win the day with that. I have seen so many situations where people avoid service thinking that if they just can avoid that, they're not going to have to deal with it. And it really has negative and horrible consequences. Here's why. In most jurisdictions, if the process server can't catch you at home, the creditor is going to go to the judge and say, look, judge, we tried to come by 6 or 7 times. We can never get Mr. or Mrs. So-and-so home. We think they're avoiding service. And so we want you to issue something called an alternative service order. An alternative service order is where the judge says, okay, creditor, you did your best to try to serve them directly. I'm going to give you permission to go there and just tape it to their door, to put it in their mailbox, or to even send emails. In the old days here in Arizona, where I practice law, they even allowed them to publish it in the classified section of a newspaper where no one ever saw it. And the problem with that is when a judge issues an alternative service order, it means that the creditor has satisfied the requirement of service and the clock is now ticking. And if you don't respond timely, you're going to end up with a default judgment, which of course will happen because you won't even be aware that it happened. So before we even get in what to do once you've been served, my number one piece of advice is don't avoid service. Get the complaint, get the summons, let's deal with it head on and put a plan together on how to get you back on track. Okay, so after you've received service, that first 48 hours, the first thing I'm going to tell you is take a breath. It's going to be okay. You know, like I said, I know everybody gets served and they go to this dark place where worst case scenario, people think they're going to jail. People think they're going to lose everything. They're going to lose their home. They're going to lose their car. Just take a moment to take a breath. This is going to be okay. We can deal with this. We can put a plan together and show you how to resolve it so that it's not something that's going to go to that worst case scenario. So that's just my first piece of advice. You're going to be okay. Regardless of what kind of debt collection lawsuit it is, we can put a plan together. Okay, the second thing that you need to do is to carefully review the summons and the complaint. Read through each and every page of it. You're going to see a lot of kind of boilerplate type language in there that they use. Maybe it looks like a form. It's still important to read it because there's some very important dates in there that you're going to need to be able to defend the lawsuit, to settle it. Whatever it is you're trying to do, the dates are going to be in there. Now, the summons specifically will tell you how long you have to respond to the allegations in the complaint. Now, depending on your state, there may actually be a date set for you to go to court. But in a lot of states, like in Arizona, where I practice law, there is no court date to start off. What they're going to do is give you time to respond in writing to the allegations in the complaint. Now, if you look at the complaint, there's typically numbered paragraphs where they go paragraph by paragraph stating what it is that they're alleging against you. Essentially, what the court wants to know, what is your response? They want to know, do we have a dispute here? Do you disagree or agree with what it is that the creditor is saying? And so it's important that you look in the summons because it's going to give you a specific time frame. Now, it does vary from state to state, and sometimes even from court to court is within various states. Again, I practice law in the state of Arizona. You have 20 calendar days to respond to the lawsuit, whether it's a justice court lawsuit or a superior court lawsuit. You have 20 calendar days. So we include weekends, holidays, everything else. And it's important that you take that date, which is actually my third piece of advice, is that you need to put that date in your phone, in your calendar, whatever you use to keep track of dates. It's an important date because if you do not respond timely, what'll happen is the creditor can then seek to have the court issue a default judgment against you. The default judgment is the worst way to go in this. If you get a default judgment, once the creditor has that judgment, they then have power to do things like garnish wages, garnish your bank accounts. They can record it with the county recorder and will act as a lien against real estate that you have in that particular county. Not only that, but if you get a default judgment, you're going to see that no matter what they're suing you for, there's likely going to be added interest, attorney's fees, court costs, and it's going to balloon up to this thing that's totally out of control, which kind of brings it to the point why you need to make sure that you have that deadline in your calendar is because if there's no judgment, you still have some negotiating power. You can still present your defenses. And a lot of times there are strong defenses to these types of cases. But if you let it go to default, then you're in a situation where all the power has been shifted to the creditor and you're not going to have a chance to adequately respond to it. So that the third thing there is that you need to do is to make sure that you put it in your calendar and you know what that deadline is to file a written answer. Now, the next piece of advice or tip that I would give you is this is when, you've reviewed the complaint summons, you put it in your calendar, you've taken that deep breath, and maybe the very next day you need to think, okay, do I need a lawyer to help me with this? Now, take this for what it's worth. You're listening to a lawyer who's telling you, do you need a lawyer? Yes, I think you're going to get a better result if you have a lawyer. The reason why is because the lawyers are aware of the rules of procedure, the processes, the things that need to be done to make sure that you don't end up with a default, but also the things to look for to determine if there is a valid defense that can be asserted against the creditor, and you can get generally a much better overall settlement if you have an attorney. Now, this is particularly true if you're dealing with a very large debt or a very complex situation. If there's a defense like an identity theft defense or some type of defense where the statute of limitations is run, something where you might need an attorney to be able to assert your legal rights. Which leads to my last bit of advice. Within those first 48 hours after being served, it's a good idea, whether you're getting an attorney, whether you're not getting an attorney, to really evaluate what is your, what I call settlement budget. If you're going to try to settle this case, whether you have an attorney, whether you're going to contest it in litigation, whether you're going to have to expend funds to hire a lawyer, really, what is your budget to do so? I often talk about to clients here in Arizona where I practice law, when we're trying to negotiate a settlement, I need to know what's a realistic number. We don't want to overcommit you to something that's not going to work for your situation. We want to know, can you pay $100 a month? Can you pay $1,000 a month? We don't want to commit you to a $1,000 a month payment plan if really $100 a month is more realistic. So you need to take a hard look at your finances and look to see, is there a specific dollar amount that you can make on a monthly payment or a lump sum, or sometimes a combination of a lump sum plus monthly payments to be able to get a settlement taken care of. Now, you may not offer a settlement for quite a while. You may file an answer to the lawsuit. You may hire a lawyer. There may be some defenses that can be litigated in the lawsuit. But it is something to have a good idea as far as what you're able to do in the event that an opportunity comes to try to settle your case. So hopefully those tips are helpful in that first crucial 48 hours after you get served with the debt collection lawsuit. Again, take a deep breath. You're going to be okay. You can deal with this. You can put a plan together and make sure that the steps are taken appropriately, that you don't end up with a default judgment, and get this thing taken care of once and for all. Thanks for watching today.